we were going to be instructing the jury. The jury clerk apparently told our 4 alternates who reported downstairs that they were not needed and sent them home. They're being retrieved. One of them, I'm told, is 30 minutes out, but that was 5 minutes ago, Lacey Clark. But we're also trying to get the Zoom to work on the courtroom, but that'll be working when we need it. Mr. Burns wanted to address some scheduling issues, though, which we have an opportunity to do that now since we're not ready with the jury.
Yes, Your Honor, I have run into some difficulties. I mean the defense have lost roughly 2/3 or thereabout of our anticipated penalty phase witnesses. This is due to the public nature of the trial and the attendant social media yammering about it. I have many witnesses who have been contacting me since the verdict saying I can't do it. People are saying things already. I'm going to get mean comments. I'm going to get trouble at work. People are going to look at me crosswise. It's not the type of situation that could be remedied by serving them with subpoenas and bringing them in here in this circumstance where I'm begging for a man's life. I can't have witnesses shooting daggers at me 90% of the time and spending the other 10% of the time glaring at Jose. If they don't want to be here, I cannot use them, is the practical nature of it. So my plans have been quite upset in the past few days, but I'm going to have to work with what I have. What I have at this point is a prison expert who is available to testify remotely this afternoon beginning at 1 o'clock. He's available at any time from 1 to 5. I have a lady who knows Mr. Soto-Escalera in previous years. She, I think, can come and testify in person this afternoon. That is all I have ready for this afternoon. I do have, I believe, 4 of Mr. Soto-Escalera's family members flying down from Connecticut. I thought that they were getting on a very early flight this morning. It turns out they're not leaving from LaGuardia until 3 o'clock this afternoon. I will not have a chance to interview them and find out exactly what they are going to say and whether it will be contradictory to other people in the family as to what they have to say. There is some difference in perception between older members of the family and youngers. And so I'm not sure who of the 4, maybe all, maybe 1, maybe 2, that I will end up using. Mr. Richardson, of course, has expressed an interest in deposing these witnesses beforehand. So I'm not sure what exactly I'm suggesting there, but it's going to be a late night for me and Ms. Minton. These witnesses would presumably be available to testify tomorrow. And that's about as much as I can update the court right now.
And Judge, can we just approach for a bench conference, because I don't want the rest of this that I need to lay on the record aired on court TV.
Sure.
Thank you.
It was discussed here at the bench. One of the lawyers has advised me they think that one of the jurors' physical appearance was broadcast in violation of the court rule. Don't know whether that's true or not, but I do want to re-advise the media not to do that at any point, not to show the faces of the jurors. All right, so that's understood in that regard? Okay. And any word on our extra 4 alternates? We're still waiting on one. Okay. Well, let's go off the record. Let's give the Zoom a try globally as far as that's concerned. So my plan would be, based on what y'all told me, we would do whatever we can this morning with the states. The state has victim impact. Does the state have any other evidence other than victim impact?
That's all.
Okay, so we would do the victim impact. Then what would be the earliest that your prison expert or the other witness would be available?
1 p.m., Judge.
1 p.m. so that we would break till 1 p.m. do that. We would reconvene tomorrow, hoping to get those witnesses on that flew down tomorrow morning. And if you needed some extra time to talk to them briefly, we might be waiting for jurors as we were doing right now. We would do that, and then And perhaps we would have the closings either later in the morning or early afternoon, and we would just go that, so it's not a major adjustment to our schedule, right? Does that sound?
Did you say closings today?
Tomorrow afternoon.
Yes, that's
Tomorrow afternoon.
fine. The only,
Doesn't that accommodate everything for the defense? I believe it does, because you have your people, they have their people flying in today, then you'd have them tomorrow, and we were able to do the closings tomorrow afternoon.
Oh, I could probably survive it, Judge, yes.
Yeah, why not?
so to be clear, tomorrow morning I would have an opportunity to at least speak to these folks. And
Yeah, if they're here,
They
and-
present
yeah.
their evidence, and then we just close in the afternoon. Yeah, that's fine with the state.
Yeah, so that would be the plan,
Yeah. that
to
works.
accommodate the communication snafu regarding the witnesses flying down. That's what caused us the difficulty logistically. And let's get the Zoom straightened out, though. We don't have all of our 16 jurors yet. All right. I'm gonna go off the record momentarily.
Where I believe some, if not most, of our Connecticut people will be speaking in Spanish. We will need an interpreter for that.
Okay, court certified interpreter.
And Judge, we'll need them here at 8:30 because the state intends to interview our witnesses at 8:30 in the morning tomorrow
Okay.
morning so that the interpreter can interpret for the state.
Thank you.
Let me show who's in charge of the interpreters now. But I will let Deputy Court Administrator know. It looks like you're getting in now. Yep. So what I'm gonna do, Tim, I'm gonna leave it on, but there'll be no audio for them, but I'll just, actually, now that we're good, before we break, we'll restart it, because it times out. So I'll just shut it off, but we've got the Zoom working now. Okay. Let me go off the record. I think I need to tell the jurors when they're not ready to come in yet, but when they do come in addition to re-admonishing them about the media coverage and not to talk to anyone, I think I should tell them our timeline. What I think is, it's going to be a little quick this morning. We're going to have some witnesses this afternoon, have witnesses tomorrow morning, then the case will be argued to them tomorrow afternoon. Otherwise, they're going to come in here for all of about 15, 20 minutes, and I'm going to release them to 1 o'clock, and they're going to be wondering what the heck is going on and maybe start getting concerned about their own time. So if I do that, it's kind of preparing them for what's going to happen. Is that all? What I'll say is, I'm thinking of saying, because as they'll see, there's a lot of logistics involved with the nature of this proceeding. It takes some maneuvering and adjusting, and that's what's caused the situation. They shouldn't be concerned about that. But once they know, we'll have the case submitted to them tomorrow afternoon. They should be fine. All right, we're still waiting for that other juror to come up, right?
Yeah.
Okay, go off the record.
Liz.
She's there? Okay. Oh, okay. All right, so it looks like you've got a few minutes to prepare your video, audio, which you're preparing. All right, the jury is present. Good morning once again, ladies and gentlemen of the jury. And before we get started, at this juncture in the trial, I know that I have drilled into your heads, hopefully successfully, to be sure to avoid any media coverage of the case. Also, not to talk to anyone about the case, including your fellow jurors, although we're past deliberations in the guilt phase, but that rule applies now too at this time. Don't talk to each other about this point in the trial until you go back to deliberating the case. But because of the vast media attention that this case has attracted, I want to be absolutely sure to reiterate to you, although I think I've got the message clear once again, in an abundance of caution, please don't talk to anyone about the case. And I appreciate that you are following the court's instructions in that regard, so that you base this part of the proceeding only on the evidence presented in court that you've already heard in the guilt phase of the trial and that you will be hearing during the sentencing phase. Before we get started and I give you instructions about this part of the proceeding, I do want to tell you in advance, give you an idea of logistically, procedurally, how we're going to be going forward over the next 2 days. And my primary goal there is to assure you that our intent is to submit this case to you for your decision tomorrow afternoon. Cases at this juncture involve great logistical challenge that are beyond the control of the attorneys. They do the best they can, but witnesses will be called who are either at or coming from very far away places, and you all are aware of what is involved with travel. So therefore, what's going to happen this morning, we're going to have some very brief testimony this morning. We're going to break. We're going to start this afternoon at 1 o'clock. We're going to have some testimony this afternoon. And then after that, we'll break. We'll come back tomorrow morning, have some testimony in the morning. And then the goal would be to submit the case to you with arguments and instructions on the law in the afternoon where the case is submitted to you. The reason I'm telling you that is I anticipate some of these breaks could be significant beyond what we would normally have done during the guilt phase. So I just want you to be prepared for that, and also not to concern yourself with it, just to be patient. But I think it'll help you being patient if you know the grand scheme as far as when the case will be submitted to you, which is tomorrow. So I believe your participation in this matter will be ended tomorrow afternoon. That's the schedule. So now that I've explained that, members of the jury, you have found the defendant guilty of 1 count of first-degree murder of Tania Wise and 1 count of first-degree murder of her unborn child. The only issue before you in this phase of the trial is to determine the appropriate penalty as to these crimes. The penalty for each of these crimes is either life in prison without the possibility of parole or the death penalty. Before proceeding further, it will be helpful if you understand how this proceeding will be conducted. The attorneys will have an opportunity, if they wish, to make an opening statement. The opening statement gives the attorneys a chance to tell you what evidence they believe will be presented during the penalty phase of this trial. As you know, what the lawyers say during opening statements is not evidence, and you are not to consider it as such. After the attorneys have had the opportunity to present their opening statements, the state and the defendant may present evidence. Witnesses may be called to testify under oath. If so, they will be examined and may be cross-examined by the attorneys. Documents and other exhibits also may be produced as evidence. This evidence, along with the evidence that you heard during the guilt phase of this trial, is presented for you to determine whether the state proved beyond a reasonable doubt the existence of the alleged aggravating factors. If so, you must weigh whether the proven aggravating factors are sufficient and whether the aggravating factors outweigh any mitigating circumstances the defendant proves by the greater weight of the evidence. Finally, you will decide whether the defendant should be sentenced to life in prison without the possibility of parole, or to death. At the conclusion of the evidence and after argument of counsel, you will be instructed on the law that will guide your deliberations. An aggravating factor is the only circumstance recognized by Florida law that could result in a defendant receiving the death penalty. An aggravating factor increases the gravity of a crime or the harm to a victim beyond the harm inherent in every first-degree murder. You must unanimously agree that an aggravating factor was proven beyond a reasonable doubt before it may be considered by you in arriving at your sentencing decision. The aggravating factors alleged by the state in this case as to both victims are: 1, as to both victims, that the defendant was contemporaneously convicted of another capital felony. This is based on the conviction as to the victim involved in the other count. As to both victims, the capital felony was committed for financial gain. That's number 2. Number 3, as to both victims, the first-degree murder was committed in a cold, calculated, and premeditated manner without any pretense of moral or legal justification. The term cold means the murder was the product of calm and cool reflection. The term calculated means having a careful plan or prearranged design to commit murder. A killing is premeditated if it occurs after the defendant consciously decides to kill. The decision must be present in the mind at the time of the killing. The law does not fix the exact period of time that must pass between the formation of the premeditated intent to kill and the killing. The period of time must be long enough to allow reflection by the defendant. The premeditated intent to kill must be formed before the killing. However, in order for this aggravating factor to apply, a heightened level of premeditation, demonstrated by a substantial period of reflection, is required. A pretense of moral or legal justification is any claim of justification or excuse that, though insufficient to reduce the degree of murder, nevertheless rebuts the otherwise cold, calculated, or premeditated nature of the murder. And aggravating factor number 4 relates only to count 2, the first-degree murder of the unborn child, and that is the victim of the capital felony was a person less than 12 years of age. Once the state has presented evidence of the existence of aggravating factors, victim impact evidence may be presented. Such evidence is only presented to demonstrate the victim's uniqueness as an individual and the loss to the community by the victim's death. However, victim impact evidence must not be considered by you as an aggravating factor. Mitigating circumstances. A mitigating circumstance can be anything that might indicate the death penalty is not appropriate for the defendant. It is not limited to the facts surrounding the crime. In other words, a mitigating circumstance may include any aspect of the defendant's character, background, or life, or any circumstance of the offense that may indicate the death penalty is not an appropriate sentence in this case. Whether a mitigating circumstance has been proven is an individual judgment by each juror. A mitigating circumstance need not be proven beyond a reasonable doubt, but must be proven by the greater weight of the evidence. After the evidence has been presented, the attorneys will have the opportunity to make their closing arguments. Following the closing arguments by the attorneys, the court will instruct you on the law. After the final instructions are given, the alternate jurors will be released, and you will begin your deliberations. You should not form any definite or fixed opinion until you've heard all the evidence, the arguments of the lawyers, and my instructions on the law. Once again, until that time, you should not discuss the case among yourselves or anyone else by any means whatsoever. Your decision must be based solely on the evidence or lack of evidence and the law. The same rules and procedures regarding your possession and use of cell phones apply to this phase of the trial as well. At the end of the case, while you are deliberating, you must not communicate with anyone outside the jury room, and you cannot have in the jury room any cell phones, computers, or other electronic devices other than those that we would provide to you as we did in the guilt phase. Once again, you must not conduct any investigation of your own. The same rules continue to apply. Just as in the guilt phase of this case, a defendant has the absolute right to remain silent. From the exercise of a defendant's right to remain silent, a jury is not permitted to draw any inference regarding the existence of an aggravating factor or an appropriate sentence, and the fact that a defendant did not take the witness stand must not influence your sentencing decision in any manner whatsoever. We now begin with the opening statements of the attorneys, and the state may proceed with its opening statement.
Morning, everyone. All right, so as you've already found the defendant guilty of first-degree murder of Tania Wise and first-degree murder of what would be her second son, the defendant's fifth child, Josiah Wise. And as the judge just explained to you, all of the evidence that was introduced during the guilt phase applies in the penalty phase. So all of the evidence that you learned, all of the testimony, that all applies in this case, and if you need to bring it, it'll go back with you again if you need it. So what is the first step that we talked about? And this goes back to jury selection. The state has to prove each of the aggravating factors beyond a reasonable doubt. And what you'll see when you go back and you think about the evidence that from the guilt phase applies to this case is that has all been proven. Each one of those have been proven by beyond a reasonable doubt. And the judge talked to you about 4 different factors. 3 of them apply to both victims. And when we talk about both counts are independent of themselves. The defendant can get a death sentence on both counts. He can get a death sentence on one or the other. He can get death for first-degree murder of an unborn child, or he can get the death sentence on just Tania Wise. He can get life on both counts. That's your decision. But what the evidence that was presented in this case already shows is that each and every one of those aggravating factors has already been proven beyond a reasonable doubt. And when you use your common sense, it's pretty clear. Because what's the first one? Contemporaneous, there's a capital conviction. Both of the murders you've already found him guilty of. That's what that factor is. It's been proven you've already found him guilty of both murders at the same time of both the victims. That factor's been proven beyond a reasonable doubt. What's the next one? Financial gain. How has that been proven? He told us in the garbage truck, I'm going to lose everything. I'm going to lose it. He needs to stop this before he has another child. It's going to ruin his marriage. It's going to cost him money. There's a potential for there to be a separation. He's got a new child to take care of. He wanted to eliminate the possibility of his wife finding out and the existence of him having another child. He did this for a financial gain. He tells Eric Alvarado days and times over and over again, what is his situation? It's been proven beyond a reasonable doubt. The fourth one that applies to just the victim, once again, you use your common sense. You think about this, the victim was less than 12. We know the gestational age of the baby. She was 8 months pregnant. Once again, the evidence that's already been presented in this case proves that beyond a reasonable doubt. So when you go back there, the first step should be those three easily proven beyond a reasonable doubt. What is the last one? It was done in a cold and calculated and premeditated. And the judge, he defined those to you. Cold is a cool, calm reflection. Let's go back to the garbage truck video. He planned this out for days, over and over again. He drives around in his garbage truck discussing, should I do it this way? Should I blow her brains out? Should I choke her? Would it be easier to get it done with one blow and be done with this? They look at many different spots of where he's going to dump the body. Is anyone going to find her out here? He thinks about what her life is like. No one's going to be looking for her. He talks about how he's going to lure her out there. It's all been proven beyond a reasonable doubt. Any one of the 4 aggravating factors in and of itself can justify the death penalty if you go through the whole process and you follow the laws instructed by the judge. All 4 of them can, but each one is independent of itself, and the first step is, do you find that there are aggravating factors? And the evidence shows yes, all 4 of them are there. Now, do those aggravating factors justify the death penalty? Yes, I encourage you that they do. And when you go back and you look at all of the evidence in this case, you look at the aggravating factors, you consider the mitigating circumstances, the appropriate sentence is the death penalty in this case. Thank you.
Thank you. And the defense is in the position to make an opening statement at this time, Mr. Burrows.
Thank you.
Thank you.
Ladies and gentlemen of the jury, good morning. Good morning. I have waited long to address you, but more about that later. The state will, I think, likely prove, probably already has, that this killing was done coldly and calculatedly and premeditatedly. I think they're going to prove that to you. So I think you probably will have an aggravator in your pocket. And I think regarding the victim, Josiah, who looked in the autopsy photos so much to me like a newborn baby, I think you're certainly going to find that he is under the age of 12. And this is the opportunity where I will tell you what the mitigators will be and what my witnesses will be and who they will be and what they will say. And I would love to tell you all about it, but I don't know. Since the conviction, many of my witnesses have melted away. They won't be here. Victims of their own moral cowardice, in my opinion. I could compel their appearance by subpoena, but I'm here to beg for a man's life, and I don't want people in the witness chair who don't want to help me do that. So I can't tell you exactly what's going to happen beyond this afternoon. This afternoon, I will present a witness. His name is Raul Banasco. He is an expert in prisons, in the Florida prison system. He's worked in Florida, he's worked in other states. And he will tell you about the prison system and how Jose will fit into it. If you do vote to condemn him to death, I think your knowledge and common sense tells you that he will exist as a prisoner for years until that happens. And if you should vote for life without possibility of parole, then he will exist in prison forever and ever. And Raul Banasco will tell you how that might be, so that you have a fuller picture there. You will also hear from a lady who knew Jose a long time ago, knew him well, knew him intimately. She will come in and testify. She, at least, is not afraid of what people on social media might say about her. She will come in difficult circumstances and tell you a little bit more about Jose. That's all I have for this afternoon. The judge mentioned travel problems. That's my witnesses. We have a problem wrangling them and getting them here from Connecticut. I do expect that we are going to have some of Jose's family members arrive this afternoon in Palm Beach. We will speak to them this evening. The state will have a chance to speak to them tomorrow, and you will hear from 1 or 2 or 3 or maybe all 4 of them tomorrow. I'm not sure how many are actually going to get on the plane. And so I don't want to leave you in a mystery. I wish I could tell you who's going to be here and what they're going to say, but you and I will learn together probably. But the thrust of the matter is that you will have plenty of mitigators to consider. And because I am missing witnesses, will probably alter and enlarge some portions of my intended argument that will be addressing what it might mean to you and how you will make your moral decision. As you have learned in jury selection, it's your own personal moral decision. I'm going to offer you, how about that, some guidance in that way. So you will hear some witnesses for the defense this afternoon. I think you will hear from some of Jose's family members tomorrow. And then I think you're going to be making your decision or retiring to deliberate about it at some point tomorrow. That's all I have for you right now. Thank you.
Thank you, Mr. Burns. And the state may proceed with its case.
Yes, sir. The people of the state of Florida call Elizabeth Bedolla.
Please stop right here. Raise your right hand and face the clerk.
Do you swear or affirm that the evidence you're about to give will be the truth, the whole truth, and nothing but the truth?
I do.
Thank you.
Over that with you. Stand.
Good morning.
Good morning.
You've testified before, but go ahead and state your name for the record and spell your last name, please.
My name is Elizabeth Bedolla. It's Bedolla.
Okay. And again, just for the sake of clarity, go ahead and state your relationship with Tania Wise.
Tania was my daughter.
Okay. And did you prepare a written victim impact statement?
That's correct.
Okay, I'm going to show you what has been marked as Court's Exhibit Number 1. You recognize this statement?
Yes.
Is that the statement that you prepared for the jury today?
Yes.
Okay. When you feel like you're ready, please go ahead and read that statement to the jury.
My name is Elizabeth Bedolla, and I am the mother of Tania E. Wise and the grandmother of her unborn son, Josiah Thomas Wise. I am here to speak about the loss of my Tania and Josiah and how their death has forever changed my life and my family's life. Tania was lovable, caring, a devoted mother. She had a beautiful soul and was always willing to help and take care of her family. She enjoyed being a mother more than anything in the world. She loved spending time with her son Jamar, playing with him, cheering for him in all his events, and making sure he always felt loved and supported. Tania was so excited about becoming a mother again. She always spoke about giving birth and how great of a mother she would be once more. She had so many dreams for Jamar and Josiah, dreams of raising them, guiding them, creating happy life together. Those dreams were stolen from her, from us, from the child who will never have a chance to grow up with his loving mother. Every memory with Tania was special. I clearly remember the last time we were together as a family. Her stepdad, her son, Tania, and I went to the beach. We laughed, we played, we had so much fun. It was one of the happiest days we had together, and I will cherish it forever. Another beautiful moment that I remember was her baby shower, surrounded by family, celebrating new life that we were waiting for to welcome. Those were the last 2 times we had with Tania. That were memories I will hold on in my heart for the rest of my life. The emotional impact of losing my Tania and Josiah is unbearable. I cannot sleep at night. When I do, the nightmares are horrific. Birthdays, holidays, and even simple dinners bring so much emptiness, loneliness, and pain because she's not there. I'm unable to function properly at work or in my daily life. I miss her so much. My baby girl. She was my baby girl, my only girl. And losing her has broken me in many ways I cannot explain. The grief is overwhelming. I live in constant pain, not only in my body, but also in my heart. A heart that never goes away. It never goes away. I'm angry. I'm angry because I don't have Tania and Josiah here with me to love and joy and share my life with every day. They should have been here. Instead, I'm left with grief, sadness, and memories. That anger is part of my pain, and it will never leave me. I still have problems accepting that she's gone. I catch myself thinking that she will be here with us tomorrow, and that I hear her voice or see her smile. But tomorrow comes, and she's still not there. That reality is crushing, and it's something that I struggle with for the rest of my life. Her son, Jamar, who was only 8 years old at the time of her mother's murder, misses his mom every single day. The sadness and the trauma that this has caused him is something no child should ever have to carry. Jamar struggled with the loss deeply, and it breaks my heart to see him growing up without his mother's love, guidance, and presence in his life. Our house was one full of laughter and energy, and it's now quiet. Tania was the life of our home, with her smile, her joy, and the way she played all around with Jamar. Now the light is gone, and our home feels dark and empty without her. The pain is not mine alone. Tania's stepfather, her son, brothers, grandparents, aunt, uncle, and cousins are all suffering as well. Many of us are battling depression, trauma, PTSD because of this tragedy. Our entire family has shattered, and the weight of the grief follows us every single day. The stress of losing Tania and Josiah has also affected my health. I have a heart condition. It has grown worse because of the grief and the stress I carry every day. This tragedy has taken serious toll on my body, broken, and has also broken my spirit. And it's not just me, it has also taken physical and emotional impact on our son, Jamar. I grapple daily with the loss of Tania, his mother. I wonder how the future will be. And I wonder how Jamar will grow up without Tanya, and how our family will find a way to live with this emptiness. Nothing feels certain anymore without her. The future we imagine is gone, and we're left trying to survive in a world that feels hopeless and broken. Tanya has already missed so much, and she will continue to miss every important milestone in Jamar's life. She will not be there for his accomplishments, his graduation, even his wedding day one day. She will never get a chance to hold her grandchild. These are moments that should have been hers as a mother, but they have been stolen from her and from all of us. Nothing can bring Tanya and Josiah back. The future we dreamed of, the milestones, the celebrations, the simple everyday moments have been stolen from us. I will never see my daughter raise her children. I will never see my daughter raise her children. And I will never get to hold my grandson. Our loss is permanent. And it has changed me and my family forever. The death of our pain and devastating impact of this crime has had on me and my family the most important, but most importantly, my grandson, who will now become into a life without a mother, is simply unfathomable. We will live with this grief for the rest of our life. What happened to my Tanya and Josiah will affect me forever. And I don't know how to live without her. She was my baby girl, my only girl. I will carry this pain every single day of my life. Nothing will ever take away this grief, the anger and the emptiness that their loss has left me behind. In the end, 2 innocent lives have been stolen from us, and we will never fully recover from this loss.
Ma'am, I want to show you what has been marked as court exhibit, photo composites, court exhibit number 1. Are these 30 photographs of Tanya that show her throughout her life?
Yeah. Yes.
And do all these photos show Tanya at various stages of her life?
Yes.
Your Honor, permission to publish?
Any objection to introducing the item and publishing it?
No, Your Honor.
Those items will be introduced into evidence and published. And you may step down. And the state's next witness.
Yes, sir. The people say the Florida called Tracy Hamill. Tracy Hamill.
Let's see. Hold on.
Tracy Hamill.
Does she need to be sworn?
I don't know what your, I don't know who the witness is or what your plan is, so it depends on.
Victim advocate who's going to read several victim impact
Okay,
statements.
so I'm not, she would not be sworn at this time. She's going to simply be reading a statement of another person, okay?
Yes, sir.
It's not sworn testimony. She can simply read the document.
Ma'am, can you state your name for the record and spell your last name?
Tracy Hamill, Hamel.
Okay, and what do you do for a living?
I'm a victim's advocate at the state attorney's office.
Okay, and as part of your duties as a victim's advocate, do you sometimes read prepared statements for those people who may not be in an emotional position to do so for themselves?
Yes.
Okay, I'm going to show you what has been marked as Court's Exhibit Number 2 for identification purposes. Do you recognize this?
Yes.
Okay. What is that?
This is Lenora Bedola's victim impact statement.
Okay. Can you go ahead and please read that to the jury?
Yes. My name is Lenora Bedola. I am Tanya's stepsister, as well as her best friend. I am here to speak on behalf of myself, my family, and the loss we have all suffered since Tanya and her unborn child Josiah were taken from us. Tanya was a loving mother, a hard-working woman, and a bright light in all of our lives. She had an incredible sense of humor that made everyone around her feel at ease. She was so smart and resourceful, always looking out for others and putting them first. But above all, Tanya was my safe person. She was the one that I could confide in, the one who always knew how to make me laugh or comfort me when I was struggling. I told her everything, my joys, my worries, my fears. Not being able to speak to her anymore has left a hole in my heart that nothing can fill. Since her death, I have cried every day. I wake up with the ache of her absence, knowing that my kids will never get to spend time with their TT Tiny. We won't be able to go to the beach together again or share simple moments like going to the mall or eating out with our kids. I moved to Florida for the summer just to be closer to her, hoping we could make more memories, and now I'm left with the empty space she once filled so effortlessly. The pain of not having her here is unbearable. I miss the small things, the smell of her hair when she got out of the shower, her smile, and the warmth of her hugs. These are things I will never get to experience again, and it hurts more than I can express. Life is not the same without Tanya. It will never be the same. There is a constant weight of sadness in everything I do, and I feel lost without her by my side. She was a part of my everyday, and now that part is gone. This profound loss that has shattered our family. Tanya was not just a victim of this crime. She was a daughter, a mother, a sister, and a friend. Josiah, her unborn child, was a life we all looked forward to, and his loss is felt deeply. We are left behind with an emptiness that words can barely capture. I will carry the pain of losing Tanya with me for the rest of my life, but I will also carry the love she gave. She was taken from us far too soon, and nothing will ever fill the void she has left.
Thank you. I'm going to show you what's been marked as court exhibit number 3. Do you recognize this document?
Yes, I do.
What is that?
This is the victim impact statement for Michael Reveron.
Okay. Can you go ahead, please read that when you're ready?
Yes. My name is Michael Reveron, and I am the proud older brother of Tania Wise. Tanya wasn't just my sister. She was one of the strongest, most caring people I've ever known. She had this rare gift of being the life of the party wherever she went. Her laugh was loud, her smile was real, and she had a way of lighting up a room just by walking in. But beyond all the fun and energy, she had a heart full of love for her family and friends. Even though I was the older brother, Tanya always acted like she was my second mom. She looked out for me in ways I didn't always notice at the time, but I feel every day now. She would show up at my job just to take me out to lunch. She would also come to my job just to spend time with me, sometimes staying for hours just to talk, laugh, and be together. She always offered support, encouragement, or simply a listening ear whenever I needed it. Some of my favorite memories are the simple ones. We used to go to the movies together, just me, Tanya, and my nephew Jamar. We'd laugh, share snacks, and just enjoy being around each other. That was our thing. It was peaceful. It was fun. Birthdays and holidays still feel empty, even after all these years without her laughter and presence. What used to be moments of joy are now constant reminders of what we have lost. Losing Tanya has left me broken in ways that are hard to write. I feel anger, sadness, and emptiness all at once. I feel like a part of me is missing. I struggle to focus and to move forward because so much of my strength and happiness came from her. Even as her older brother, she made me feel grounded. Some days I find myself grabbing my phone trying to call her to tell her about my day. On top of the grief, I now live with PTSD, depression, anxiety, and nightmares because of what happened to her. I relive the pain over and over in my mind, and some nights I wake up shaking and crying. It has taken a serious toll on my mental health, my sleep, and my ability to function day to day. The future has been forever changed without Tanya. I think about all the milestones she will never get to experience. She will never see her nieces and nephews grow up or witness all the things they will accomplish. She will never meet her grandchild. She will miss the wedding we always joked I'd never have. I will never get to meet my unborn nephew or see all the great things he would have done. For me, I will never again have my sister, best friend to share memories with or to laugh with. Her absence leaves a void in my life that can never be filled. I hope that by sharing who Tanya was and how she lived, that the court understands the depth of loss. We're not just grieving her absence, we're grieving everything she would have continued to be: a loving mother, a joyful sister, a loyal friend, and a light in our lives. This isn't just about the life that was taken from Tanya and my unborn nephew, but the lasting impact their loss has had on me, my family, and all who love them. No words can fully capture the pain, emptiness, and grief we carry every day. Depth of our loss knows no bottom or end.
And I'm going to show you what has been marked as Court Exhibit 4. Do you recognize this document?
Yes, I do.
What is that?
It's the victim impact statement for Reyes Bedolla.
Okay, and when you're ready, can you go ahead and read that quickly, please?
My name is Reyes Bedolla. I am the stepfather of Tania Wise and the grandfather of her unborn son, Josiah Thomas Wise. I would like to talk about how much I miss them and how hard it is to live without them. Tanya was amazing, funny, helpful. She was a bundle of joy. She was a loving, caring, and devoted mother who loved to play around with her son. Everywhere she went, she would smile. She was always there giving a helping hand to the family. She touched everyone with her kindness. We had built a strong bond. I knew her dream and what she wanted to do with her life, and I was going to be there every step of the way to support her. Her life was about her children and raising them. Losing her in this way has left me with a pain that never ends. I looked forward to welcoming my grandson Josiah into the world, but am now heartbroken as I have to come to terms with the fact that this will never happen. All I am left with are dreams of what he would be like today. Every time I see somebody else with a child, I imagine my beloved grandson and wonder about the things that could have been. I would have loved to watch Josiah take his first steps, play sports, and grow into a man. I will never hold him, play with him, or even spoil him, and he will never call Grandpa. I am so hurt my life will never be the same. I am raising Tanya's son Jamar, and I see how he suffers for his mother. This emptiness that my family and I can never be filled. I ask myself, why are Tanya and Josiah? We struggle to move forward every day. I remember going to the beach with my wife, Tanya, and her son Jamar. It was all about spending quality time together, and we all planned our future. Our conversation were all about family. I don't have this anymore. I have never been able to go back to a fun day at the beach as our family feels like we are not complete and are broken, and we are trying to piece it together to continue our next day. Our family is struggling to move forward while trying to honor their memory. Nothing will ever be the same.
Thank you.
You're welcome.
Thank you. And the people of the state of Florida call Johnny Reveron.
So if you raise your right hand and face the clerk.
Do you swear affirm that the evidence you're about to give will be the truth, the whole truth, and nothing but the truth?
Yes, ma'am. Witness stand.
Morning.
Good morning.
Can you state your name for the record and spell your last name, please?
Yes, it's Johnny Reveron. Last name's Reveron.
Okay, and did you know Tania Wise?
Yes, she was my sister.
Your sister, okay. I'm going to show you what's been marked as court exhibit number 5. Do you recognize this?
Yes, sir.
Okay, is that the statement you prepared?
Yes, sir.
Okay, when you're ready, go ahead and read that to the jury.
Yes, sir. My name is Johnny Reveron. I am Tanya's older brother. I stand before you today to speak not only for myself, but for my family and for Tanya's unborn child, who was never given a chance at life. The loss of my sister has devastated every part of my life. Tanya was not just my sister. She was my friend, a piece of my heart. She was carrying her child with such joy and anticipation. That child should be here with us, loved and cherished. But this life was taken before it even began. Just a month before this tragedy, Tanya and I spoke after she started working at the same company where I work. We talked about her excitement for this new chapter and how much she was looking forward to building her future. I never imagined that it would be one of the last meaningful conversations I'd have with her. Since her murder, my world has been turned upside down. I wake up every day with a heavy heart, knowing I may never hear Tanya's laugh, see her smile, or share the simple everyday moments that brothers and sisters are supposed to have. Holidays, birthdays, and family moments are now filled with pain because Tanya and her baby should be here with us. This tragedy has not only caused unbearable emotional pain, it's left lasting scars on my family's sense of security, stability, and peace. I struggle with grief, anger, and unanswered questions. I have lost sleep. I have lost hope. And I will carry this pain for the rest of my life. Tanya and her baby deserve to live. They deserved a future full of love and opportunity. Instead, what remains is a permanent void in my heart and in my family's life. Thank you for allowing me to share on how much I miss my sister.
Thank you. Thank you, sir. Thank you. People in the state of Florida call Yaritza Irizarry.
Ma'am, if you could just raise your right hand and face the clerk.
Do you swear affirm that the evidence you're about to give will be the truth, the whole truth, and nothing but the truth?
I do.
Thank you.
And for the witness stand.
Morning.
Good morning.
Can you state your name for the record and spell both your first and your last name, please?
Jaritza Irizarry, Jaritza. Last name Irizarry.
Okay. And did you know Tania Wise?
Yes, she was my niece.
Okay. And I'm going to show you what has been marked as court exhibit number 6. Do you recognize that document?
Yes, I do.
Okay, is that the statement that you prepared to deliver to the jury?
Yes.
Okay, when you're ready, go ahead and read that to the jury, please.
Your Honor, my name is Jaritza Irizarry, and I am the aunt of Tanya. To me, she was more than a niece. She was like a daughter. Tanya was beautiful, loving young woman whose life was taken from us in the most painful and senseless way.
Her death has left us a permanent hole in my heart and in the heart of my family. Tania was a devoted mother. She loved her son Jamar with everything she had, and she was overjoyed to be pregnant with another baby Josiah. Not long before her murder, I hosted her baby shower. I could still picture that day, glowing with happiness, surrounded by her family, smiling as she opened gifts for her new baby. She was so full of hope for the future, so excited about raising her children, and so ready to begin a new chapter of her life. But that joy and that future were stolen from her, from Jamar, from all of us. Jamar has to grow up without his mother, and Josiah never even had the chance to take his first breath. Her loss has shattered our entire family. My sister, her mother, is broken. No parent should ever have to bury their child, and watching her live with this pain has been unbearable. Every holiday, every birthday, every family gathering feels incomplete without Tania. There is always an empty chair and a silence where her laughter should be. For me, it's the everyday moments I miss the most. We shared so many simple joys together, taking the kids to the beach, going shopping, eating out, or just cooking her favorite meal. I miss sitting with her, talking and joking around. She had this way of making everything seem better. No matter what I was going through, at times I wanted to pick up the phone and call her to tell her everything, like what I always did. But now there is only a silence. Those ordinary times that once brought me comfort and happiness now feel heavy and empty without her. The pain of losing Tania has affected me deeply, both emotionally and physically. I cry without warning. I struggle to focus to find joy in the things I once loved. I suffer from sleepless nights, nightmares, and anxiety. The grief sits in my body like a weight, leaving me exhausted and drained. A part of me died with her, and I will never be the same. The crime didn't just take one life, it took two. Tania's life was taken, and so was baby Josiah's before he ever had the chance to live. Jamar lost his mother, my sister lost her daughter, and I lost someone who was like my own child. Our family has been torn apart, and the pain we carry will never go away. Respectfully, Charitza Rosari.
Thank you. Thank you, ma'am. And people will say Florida call Jamar Bedolla Wise.
So if you can raise your right hand, please.
Do you swear affirm that the evidence you're about to give will be the truth, the whole truth, and nothing but the truth?
I do.
Thank you.
Over that way to witness.
Morning. Can you state your name for the record and spell your last name, please?
Jamar Bedolla, Bedolla.
Okay. And what is your relationship to Tania Wise?
She was my mother.
Okay. I'm going to show you what has been marked as Court's Exhibit number 7 for identification purposes. Do you recognize that?
Yes, I do.
Okay. Is that the statement that you prepared?
Yes.
Okay. When you're ready, can you go ahead and please read that to the jury?
Hello, I'm Jamar, and I'm the son of Tania Esther Wise, who was taken from us. My mother was the closest person to me, and she was like my best friend. Also, she was always there for me. I'm here to share a few to honor my mother and talk about how I was affected. Ever since that day, ever since that day, there have been many different ways that I've been affected emotionally. For example, I've developed depression, sleeping problems, and anxiety. Losing her made me grow faster than I should have. I used to hide my pain and try dealing with it on my own, and to protect myself from getting hurt more than I was, and I didn't like talking about what was wrong with me. Every day, I think about how she won't be able to see what I've accomplished and what I will accomplish in the future. She's already missed some of my milestones that I've reached, and I think that she would have been proud of them. I wish that she could have met my first girlfriend and watched me perform in my musical performances for my school. I'm in marching band. My mom was also musically inclined. She played the clarinet, and I hope that she would be proud of who I've become. On that day, I've lost more than a mother. I also lost the chance to have my mother watch me grow, and I hope that she's proud of me for coming here and talking about how this has affected me. I choose to honor my mother because she was one of the most, if not the most important people who has been in my life.
Thank you.
That will conclude the evidence from the state.
Members of the jury, that concludes the state's part of the evidentiary portion of this penalty phase. As I mentioned, we're going to break at this time till 1 o'clock. Please remember the rules regarding communication. Don't discuss this case with anyone, including your fellow jurors. Enjoy your lunch, and we'll reconvene at 1 o'clock. And please leave your notes on your chairs. All right, jury is present. We proceed with the defense mitigation evidence, and the defense may call its first witness.
Thank you, Judge. The defense calls Raul Banasco.
Mr. Banasco, if you raise your right hand, I'll administer the oath to you. Do you swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth?
Yes, I do, Your Honor.
All right, and you may inquire, Mr. Burns.
Thank you, Judge. Can you hear me, Raul?
Yes, I can, sir.
Okay, tell us who you are, please.
My name is Raul S. Banasco. I am a prison and jail expert who has been consulted to interview and give my professional opinion based on my experience in corrections and my education and training on this case.
You're on Zoom. Are you not in Florida?
No, I am actually in Austin, Texas today.
Are you working in Texas now?
I'm actually off for the afternoon, but yes, I do have a full-time employment, but I'm off for the rest of the day, sir.
Tell the jury about your education, please.
I have an undergraduate degree from Iona University in New York with a focus on psychology, minor in criminal justice. I have a master's in public administration from Florida Atlantic University in Boca Raton, Florida. I also have my certification as a public manager through the Florida Atlantic University Master's Program, and currently hold my certification as a jail manager through the American Jail Professional Commission. As well, I'm a certified corrections executive through the American Correctional Institution Organization on Professional Standards.
Are you working in jail or prison administration now in Austin, Texas?
Yes, I am.
How long have you worked in that field?
I've been in this field going on my 39th year. Started my social services, public safety career in New York, did 2 years with the juvenile system, and in 1988 joined the Florida Department of Corrections as a corrections officer at the prison now known as Central Florida Reception Center in Orlando, Florida. During my approximately 20 years with the Florida Department of Corrections, worked my professional development through classification. I served as a supervisor as well as a probation supervisor, an assistant warden at 3 major institutions, warden at a major Hernando correctional institution, also served in the capacity as director of training for the entire Department of Corrections for 2 years, and then transitioned into jail operations. I served as the major for the Orange County Jail in Orlando, the deputy chief and interim chief for Osceola County Corrections, and then retired from the Florida system, did some nonprofit work for 2 years, and then have ran jails in different states from San Antonio, Fort Worth, St. Louis, as well as now Austin, Texas.
So you have worked in corrections here in Florida.
20 years, yes, sir.
Are you familiar with Florida DOC policies and procedures?
Yes, I am, sir.
You're not here out of the goodness of your heart, are you? We're paying you for this work, correct?
Yes, sir.
How much do you charge per hour, sir?
My fees are $200 an hour to interview, review records pertaining to any case, as well as $225 an hour for testifying, and $110 for any travel time involved on any case.
How many hours have you put in on the Soto-Escalera case?
16 and a half hours.
Is this your first time testifying in court, sir?
No, sir.
Where have you testified before?
I have testified in a variety of states, particularly Florida. I've testified on various cases from Dade County, Duval County, Lake County, Marion County, Volusia County, Lee County, Gadsden County, also in the Panhandle, some of the Washington County, a variety of counties throughout the state of Florida, as well as done work in South Carolina, Louisiana, Georgia, Tennessee.
Do you testify always for the defense?
Yes, sir.
Has any state attorney's office, whether this one or anywhere else, ever used you as a consultant or consulted you on a case?
Not as a consultant, no, sir.
I'd like to talk to you, sir, for a moment or two about what life without parole would mean for an inmate so sentenced. Are you qualified to answer questions in that regard?
Yes, I am.
A person sentenced to Florida Department of Corrections to life without the possibility of parole, where are they housed? How are they housed in the system?
The way the process goes in the Florida prison system, like many, they are sentenced to a reception center in which they will go through 6 to 12 weeks going through a battery of assessment processes for mental health, medical, classification, custody review, and then they're sent to a permanent facility. An individual who's sentenced to life will always be close custody. They will be sent to a facility that has that security level. Their requirement, once they are transferred to that permanent facility, they will go through an assessment process through classification, known as the institutional classification team process, in which they will be assigned a job. Every inmate who's serving life at a facility designed, they are required to work 60 hours a week. They are required to show up to work in addition to other obligations. They will be housed in a custody level, as we know, as 804 or 805, which means their housing facility assignment will be either with another inmate or several inmates, and after dark, they are secured behind 2 or 3 additional secure doors to ensure that that custody level doesn't have access to the compound as a whole. In addition to working 60 hours a week, they're required to get up at 4 o'clock in the morning. They're required to march down to the chow hall, eat their meal within 7 to 10 minutes, return back to their assignment. They go through vigorous requirements. They get counted several times a day. They're told where to go, when to go. They have appointments to be at, and they are required to follow all the rules and regulations that the prison requires of them in that environment.
Is a prisoner serving life without parole, does such a prisoner shower every day?
Shower every day. They are given the option to shower in the evenings when the showers are open, but that is a communal shower environment in which they share in normal dormitories the ratio of maybe 15 showers for 250 inmates. There is a period of time in which the showers are open and they have to take advantage of it. If they're not in that environment at that time or overslept, they just are not showered. They're also required to go to call-outs and have other obligations in which, when it comes to either the environment, TV, they share one communal TV per pod or per unit, in which they all have to decide what channel. So there's nothing individually catered to that individual inmate serving life. They have to share it with anywhere 70 to 150 inmates in that environment.
You indicated, I think, that a typical inmate serving life without possibility of parole is required to do work?
Yes. Every inmate, whether you have an impairment, you can be a wheelchair, medically declining individual, everyone is required to have a job assignment. It can be assigned as a houseman, and in this case, most of those who are healthy, they will be given an inside grounds job, which basically means they're given manual lawnmowers, they cut grass. We're talking big acre properties within the fence line. They also prepare meals. They keep up with the day-to-day maintenance concerns. If you have any skills in maintenance, painting, repairing sidewalks, landscaping, keeping the upkeep of the prisons, of these aging prisons. They're required to work 60 hours a week at their job assignment.
And a lot of their work is done to maintain the prison that holds them.
Correct. Basically, in the business of prison world, 85% of prisons upkeep are done by inmate labor and utilizing them to keep the facility operating.
So prisoners assist in cooking and cleaning and repairing and mowing grass, you said?
Yes, sir. They prepare meals, they launder the clothes, they paint the buildings, landscaping, and any kind of repair, plumbing or framing or any kind of construction repairs that need to be done within the fence.
What if the inmate says, no, I'm not going to do this work? What happens?
What happens when any prisoner or inmate refuses to work, they will get a disciplinary report, which basically is a rule infraction. Refusing to work, and what the process is, if you refuse to work, you get placed in administrative confinement, as we often know in the business as the whole, the confinement unit. You will go through an administrative process in which the individual inmate being charged with the rule infraction will have an opportunity for it to be investigated based on the officer's report. They can call witnesses. At a period of time, they will come across the disciplinary board, which is 2 members and sometimes 3 members of the institutional classification team. At that time, they will plead their case, and that team will make the decision with what the outcome is. And in most cases, you're found guilty, and you're given a sanction of time in disciplinary confinement. And in many cases, additionally, they will take pain time. And what happens is the individual will remain in disciplinary confinement with no privileges, no access to anything but his legal paperwork, and based on their behavior while in disciplinary confinement, they will be reviewed weekly, and eventually, if they meet all the expectations, will be released back to open population.
Let us talk about inmates who are not sentenced to life without possibility of parole, but who are sentenced to death and are awaiting their executions on death row. Can you describe a death row cell to us, please?
Yes, and those, if I could digress a little, those who are sentenced to death go through a different process. They will be normally taken to RMC in North Florida, get processed within a couple of hours, and they're taken to either Union Correctional Institution. An inmate who is sitting on death row, the environment is slightly different. These are individuals that are housed alone in a 6x9 cell with their assigned toilet and stainless steel sink. They are permitted to have their own TV in their cell. They are not required to work, and they are not required to leave their cell. The meals are brought to them. Their laundry is brought to them. They have changed things on death row in the last 2 years, in which now inmates on death row have more time outside of their cells. They have visits with families. They have a tablet assigned to them where they can communicate with their family. They have day room time in which they can interact with other inmates on death row, as well as have additional recreation time outside of their cell as well.
When a death row inmate is permitted time out of his cell, does he share that time with other inmates? Is he by himself? Tell us about that.
No, he shares it with several inmates, 5 to 6, 7 inmates, when they're in the day room time, so they're in contact with other inmates on the same status on death row. Recreation, they also have access to other inmates playing basketball and having more out-of-cell time with other inmates in their same custody level.
Why are the inmates sentenced to death? Why don't they work?
The requirement is that those individuals, because of their custody level, there's very limited work assignments, and because of security grades, the expectation of the high risk, those are individuals that are classified at maximum custody, and these are the individuals, because of their sentence, have to be watched at all times and placed in a secure environment. Giving them work assignments, it's not conducive to that environment. Often they can help out if they want, but they're not required because of their custody level and the security aspects that go with it in supervising them.
Regarding death row, is there just one death row in one Florida prison and all those awaiting execution are there?
Yes, for the men, it's Union Correctional Institution, and for the women, it's at Lowell Correctional Institution.
How many are presently on death row, do you know?
Currently, approximately 458 are on death row as of today.
It seems to me there have been a great number of executions so far just this year. Do you know how many?
I think approximately 12 this year. The 13th is scheduled for sometime this month, and the next one is tentatively scheduled in late October this year.
So there have been more executions than months in the year so far.
Objection as to relevance.
Yes.
I'll have to say anything.
I was not the one who contacted you initially on this case. Who contacted you regarding involving you in this Soto-Escalera case?
That was back on June 3rd. Sherry Schwartz, Dr. Schwartz, who's a mitigation specialist, reached out to me.
So she knew of your reputation and work in this field then?
Correct. I worked with her on some other cases.
What were you requested to do?
I was requested to review all his corrections records, whether at the county jail or if he had any kind of prior prison involvement, review his assessment, have an in-person structured interview, assess the records that were provided to me, and give my professional opinion on how his adjustment has been while he's been in a corrections environment, and in this particular case for the last 7+ years.
Do you review records? What do you do?
Yes, I review records. I reviewed in this particular case over 220 records, pages of records that were provided to me for the St. Lucie County Sheriff's Office jail operations based on his state since he's been booked there.
Did you get a chance to meet with or speak to Jose at any point?
Yes, I met with him on August 1st of 2025 for about an hour and a half at the St. Lucie County Jail, in which I had an in-person structured interview to meet with him.
Has Jose been in the St. Lucie County Jail since September 2018 consistently?
Yes.
Did you review any disciplinary reports regarding Jose Soto-Escalera from the St. Lucie County Jail during his 7 years of incarceration?
Yes, I did.
How many DRs or disciplinary referrals did you see in the records?
He technically had 3, but it's the way some jails do it, they lump them together. He had a disciplinary report back in 11/14 of 2019, and it was for unauthorized area while count, in which basically he was found guilty of that. Basically, during the count time in which they account for inmates, he was not where he should have been. They accounted for him, but he was not in the assigned area, in which they keep 30 days probation, which basically means don't mess up again or we'll take your privilege of visit. And then in April 24th, 25, he had taken the table and some chairs to his cell, and when they were getting ready to lock down so he can play cards. So they actually wrote him up for having a plan and causing a disturbance to operations, in which he shouldn't have done it, but unfortunately he got caught and he was given disciplinary infraction, in which he pled guilty to.
Any disciplinary referrals regarding fighting, violence toward other inmates or towards guards?
No, none of the records provided to me show any incidents or anything relating to any kind of violence, either with other inmates or with any of the staff or the corrections officers.
Do you yourself speak Spanish, sir?
Yes, I do.
Did you talk to Jose in English or Spanish or both?
I spoke to him in English. He speaks Spanish. We might have said a few words in Spanish, but everything was English-based. The interview.
Based on your training and years of experience and having reviewed the records, is 7 years of incarceration consistently sufficient for you to review Jose's situation and render an opinion about his future behavior while in custody?
Yes, sir. 7 years is a good amount of time in which someone who comes into a jail environment, corrections environment, to assess them based on how well they adjusted to the environment, both from a medical, physical perspective as well as behaviors. Yes, sir.
And what did you conclude specifically then about Jose Soto-Escalera's suitability or unsuitability to be a prisoner?
Well, I assessed, based on my years of experience and training, here you had an individual who was booked for a crime which was well publicized. The individual has been at the county jail, which, understanding the county jail environment and the prison environment sort of has its differences, where county jails have inmates that come and go every day, from misdemeanors to major felony cases, where the population in the county jail is very fluid. Didn't see anything in his records that show that he had to remain in protective custody. Didn't see anything in his records that gave the impression or alluded to him not adjusting well. He followed all the rules. 7 years, he did receive 2 DRs. They were not major DRs. In fact, one was just getting probation. So at the end of the day, someone who's sitting in a county jail for 7 years with a fluid inmate population, where in that environment, inmates tend to try each other. They're either victims or victors. At the end of the day, he steered away from that. The records indicate he followed the rules. He stayed out of everyone's way. He didn't cause anyone any kind of challenges. And he's adjusted well in the prison, in the jail environment, which would indicate someone like him, when sent to prison, will adjust well, stature-wise, behavior-wise. He will follow the rules and regulations in that environment without any concerns, based on the records I reviewed.
When you met with Jose, did you have a chance to discuss his work history at all?
Yes, I did. Had the opportunity, part of the structured interview, talk about education, in which he told me he did not obtain his high school diploma, but he did obtain many other trades. He has experience in the carpentry field, profession, construction, laborer, framer. Some of the skills that he's mastered in the construction environment was something he was very well versed and knowledgeable and had work experience in.
Do any of those skills and abilities equip him to be a useful worker as a prisoner?
Someone like him, based on my many years of experience, particularly in classification, when they come to the reception center and end up at a permanent camp, what they do is they interview him based on his skills, because unfortunately prisons are, getting old and aged. So basically we assign work assignments. So every prison has assignments for carpenters, electricians, painters, general maintenance. And someone like him, who after a period of 60 to 90 days, who has done the entry-level jobs such as inside grounds and the heat, and they've proven to be a good worker based on the review we'll get every week and every month by the officers, will be basically assigned an assignment such as maintenance, so he can use his skills to help the upkeep of the prison. And basically it's an opportunity for the prison system to have free labor at the expense of the inmate being held accountable to perform those duties based on the need of the institution.
Did Jose's charges and current placement at the jail for these 7 years render him ineligible from participating in jail educational programs?
Based on the records I've seen, and because when you have cases like this, based on the category classification level, which he's at the highest level, they do not, most jails like St. Lucie do not offer them the opportunity to have those education programs. And most likely, when he goes into the prison system, that will be the same approach. The investment, if sentenced to life, will not be for someone like him. They will utilize him for labor, and what he can help is sweat equity and keeping the prisons upkeep.
So I'm not sure of the answer. Could you, Captain, clarify that if it's a yes or no? I'm not sure what the answer was.
Did you hear the judge?
Repeat the question. Judge, Your Honor?
Yes. Could you clarify as far as how it's been in the jail and what it would be like in general population? It seemed to me that you were equating the two, and then there was a difference between the two. I wasn't sure what you were saying, what it would be like in prison and how it's been in the jail. You want to just clarify your answer?
Okay, Your Honor, so to clarify that, so in the jail environment, there's a lot of moving population types. So when I was referencing that, was based on his adjustment in the jail environment. Most inmates who are in a jail environment for a long period of time sometimes fights and have aggressive behavior based on the type of inmates that come in and out of that jail environment. Based on his 7 years, he's adjusted well, which based on my experience, someone like him who ends up in the prison system should adjust well. The only difference in the prison environment, Your Honor, is those individuals are actually assigned to that prison for several years, and we assign them based on their labor skills and what they can do to keep the facility operating. Does that answer your question, Your Honor?
Thank you.
As long as Mr. Burns is comfortable with the answer, that's fine.
Yes, that's all right. Thank you, Judge. Now, I think you may have answered this question already. If this jury recommends that Jose be executed and that's what the judge orders, I think you said he would be welcomed into the system at the North Florida Reception Center, and then he would go immediately to death row in Union Correctional. Is that correct?
Correct. It's normally done within several hours. They basically process them and move them into death row status.
And if Jose was sentenced to life without parole, where would he go? Do you know?
Because in St. Lucie County, he would go to Central Florida Reception Center. There's actually 4 male reception centers. He will be transferred to the reception center, in which he will remain there anywhere from 6 to 12 weeks as he goes into the assessment process. And based on his medical grade, dental grade, psych grade, his assessment classification, as well as his security level, he will be assigned to a permanent prison throughout the state of Florida, and most likely will be in North Florida, where we have most of the prisons that house life inmates.
Now, in reviewing your notes here, I see that in Florida Department of Corrections, there must be facilities that are characterized as faith and character facilities. Is that correct?
Yes, they're known as faith and character based facility, and often some of them are also in conjunction with incentivized prisons as well.
And would Jose be a good fit for a faith and character facility?
The criteria for that is something he would have to earn. You have to have anywhere from 24 to 36 months in the prison system without any rule infractions, any kind of violence, in which at that point, wherever he's assigned, he can put in for that. But that goes through an assessment process, through classification, and gets approved all the way in central office. So it's something that he would have to earn and not automatically considered for.
So you have reviewed Jose's records, you have met with him, you have the experience and education that you have told us about. Do you believe that Jose could contribute and be a contributor, even if it be only to the state prison system, if he were sentenced to life without parole?
Yes, yes, sir. Yes, I do.
The jury has been told by authoritative sources before, but I'll ask you also, does life without parole mean life without parole in Florida?
Yes, everyone, because parole doesn't exist since the 80s. Every inmate who is sentenced to the Department of Corrections with life without parole will never leave the prison fence line unless they're required to go out for a medical run, in which the proper security components. Other than that, they would expire their life in prison and be removed in a body bag, sir.
Thank you, that's all I have for you.
Cross-examination?
No questions from the state.
May Mr. Bonasco be released at this time?
You may, Judge. Thank you, sir.
You're welcome. All right, I'm going to end the Zoom, sir. Thank you.
Thank you.
You're welcome. Are there other Zoomers or?
No, I have one person live.
Okay, so I will end the Zoom then. Okay. End the Zoom. And did you need a break at this time, or?
No, we can proceed unless
Okay.
the jury needs a break.
Jury need a restroom break? No, we're good? Okay, you may call your next witness.
Is Lucinda Cook, may we have her?
Sure.
Someone
Lucinda
from
Cook.
Cook.
Raise your right hand and face the clerk.
Do you swear or affirm that the evidence you're about to give will be the truth, the whole truth, and nothing but the truth?
Yes, ma'am.
That way the witness.
And you may inquire of the witness, Mr. Burns, when ready.
Thank you. Sit real close to that microphone in front of you, ma'am. Tell us who you are.
I'm Lucinda Cook.
Speak up nice and loud. Who are you?
I'm Lucinda Cook.
Okay, Lucinda Cook. You see Jose there?
I do.
How do you know him?
I used to date him many years ago.
Can you give us a time frame?
2006, for about 4 or 5 years.
2006 to 2010, 2011, somewhere in there?
12, yeah.
And how well would you say you know Jose?
I knew the man that I was with back then very well.
You know that he has now been convicted of murdering a lady and her unborn baby, correct?
Yes.
And you're not here to quarrel with the jury about that.
No.
But is it fair to say that you do not recognize that murder in the Jose that you knew?
Absolutely not.
What were your circumstances when you met Jose?
I was just getting out of an abusive relationship, a 10-year abusive relationship.
Did you have children?
I have 3.
How old were your children when you met Jose?
4, 2, and a newborn.
How did you meet Jose?
A barbecue, a friend's barbecue.
And was it a slow developing relationship or swiftly developing?
I mean, both. I mean, we dated for a year before we lived together.
Did you live together for that 4 or 5 years? Yes, I need to say yes or no.
I did.
Okay, thank
Sorry.
you. Just so the record has it.
Yes.
Everybody knows what you mean, but the record needs to be clear. And you were about how old then when you met Jose in 2006?
24, 23.
When you were with Jose, how was he with your young children?
He loves children. He was very good with them.
And how did your children react to Jose?
They liked him as well.
How did you feel being in a relationship with Jose?
I was just getting out of an abusive relationship, so I wasn't very nice to him. But he did everything he knew to do to display a great characteristic of a man that my son should look up to.
Did Jose make you feel safe coming out of that relationship?
Absolutely.
Sorry, could not hear the answer.
Absolutely.
Your children also?
Yes.
You indicated that, I think maybe as a result of where your head was at coming out of that relationship, you said you were not always very nice to Jose?
I was not nice to the man at all. Sorry.
You were mean to him, I think you characterized it. Is that correct?
Yes.
How so?
Everything was worth an argument. Everything he did was wrong. I pushed his motorcycle down the driveway. I spit in his face. Told him to leave.
When you had disagreements and arguments with Jose, did he get violent with you?
Never, ever.
I
didn't even get an argument out of him.
I think you just told us in one of your disagreements you spat upon him. How did he react to that?
Just wiped it off.
You mentioned a motorcycle. Jose had a super duper tricked out motorcycle, yes?
Yes, sir.
Paint job, lots of chrome. He loved it. What did you do to it?
Pushed it down the driveway.
Because you were angry at him?
Because he wasn't moving fast enough. I was really mean.
Oh, I'm sorry. I think you was that toward the end of the relationship. You had enough. You said you'd go, but you punctuated that request by damaging his motorcycle.
I was just mean, and he wasn't moving fast enough. I don't know.
What did he
A lot
do?
of years ago.
What did he do when you did? Did he see you damage the motorcycle?
Yeah, he was right there.
What did he do to you?
Nothing. He just picked up the motorcycle and drove away.
So, despite provocations, you have not ever seen Jose to be violent. Is that so?
I've never seen the man be violent, and his occupation was a bouncer. I never even seen him fight a man.
And even when he was working security at clubs, he wouldn't fight.
Never. He was like a clown.
But there were other women in Jose's life, correct? And that's kind of why you ended it with him. Yes.
I just had a drama-free life, and the extra drama from having multiple kids' mothers. I just didn't want my kids to witness it. Or
Yes.
I didn't want
One or more of Jose's other women would occasionally come around and interrupt your life. Is that correct?
because of their own problems, not necessarily my problems.
Would you describe Jose as easily excited and angered, or a calm person?
I'm not sure that I've ever seen him super angry, not to a violent state. I mean, mad at something, at work or something, but not angry enough to do something.
You know, earlier today I told the judge, and then later I told this jury that a lot of witnesses I was counting on didn't show up, but you are here. Why have you come?
Joselito did everything during our 4-year relationship that he should have to display great characteristic of a man for my children. He would, an example of a man that I should have probably treated a little better. And I was just, I can't sleep at night knowing that he's gonna lose his life. And I was so mean to him for no reason at all.
Well, we don't know that yet. Do you want him to lose his life?
No.
Thank you, that's all I have from you, man. Thank you so much.
Cross-examination?
So, okay, so let me just figure out the timeline here. It sounds like you started dating the defendant in 2006, is that right?
Yes, sir.
And then you broke up with him in 2013?
Late 11, 12, yeah.
2012? Okay, and if I understand correctly, you used to work down here at the gas station located at Midway and Selvas, right?
Yes, sir.
Okay, and you used to see the defendant every once in a while when he'd come into the gas station, right?
Yes, sir.
And if I recall correctly, you did not speak to him when he came in.
I never spoke to him again until recently, after I left him.
Right, so when the defendant would come into the gas station, you ignored him
And treat him like a stranger.
and treated him like a stranger, is that right?
Yes, sir.
Okay, so and then from 2012 up until just a few weeks ago, you didn't speak to him at all,
Absolutely not.
right? So 13 years went by and you didn't speak a word to him.
Absolutely.
Is that right?
Yes, sir.
Okay, and then when you did speak to him again just a few weeks ago, was that after the trial started?
I'm not sure. I didn't follow it or his situation. I've been getting phone calls from his children trying to get me to talk to him, but I didn't know why. I didn't know, I didn't follow. I don't watch TV, so I didn't know what was really going on. And I prayed on it for a while before I made my decision to help him.
Okay, but you said you spoke to him for the first time after 13 years a few weeks ago.
Mhm.
So my question is this, how many weeks? 1 week, 2 weeks, 3 weeks, 4 weeks? How many, what would you say?
Let's go with a month. I don't know. I wasn't really recording dates. I didn't think I was.
A month. Okay, gotcha. And a lot can change with somebody after 13 years, is that right?
Absolutely.
Okay, all right, no further questions.
Thank you.
You redirect?
No, Your Honor. Thank you.
May Ms. Cook be released from subpoena if she is under subpoena at this time?
Yes, sir. She's on the speech.
Any objection?
No.
No objection.
Thank you, Ms. Cook. You're released from your subpoena at this time. You're free to stay or leave as you wish. And counsel, if you want to approach.
Thank you.
Members of the jury, as I told you this morning, we're going to have a short afternoon. Those are all the witnesses for this afternoon. We are going to restart tomorrow. There's some work we need to do outside of your presence, so we're going to ask you to come in at 9:30, not 8:45. Gives you a little extra time, but we are still on course to get the case to you tomorrow afternoon. Please remember, of course, you know what I'm going to say. We're very near the end of this case. We're going to be recessing for the evening. Don't discuss the case with anyone. Don't do any research. Avoid all of the media coverage of the case. We're almost there at the end of the case. And enjoy your evening. Leave your notes on your chairs, and we'll see you in the morning, 9:30.